section here, they're just explaining why they don't need to exhaust administrative remedies, because that's what the defense said that they needed to do. And their idea. So this is item D says the following: defendants violated Ryan's Fourth Amendment right to substantive due process because they created a danger causing Ryan's disappearance and probable death. So the Tammy Larson's attorneys are saying that that's what the allegations are. The school district and staff affirmatively placed Ryan's life in danger, and the risks of his death or disappearance were obvious and known. So that makes me sad. It says here, defendants acted recklessly in conscious disregard of Ryan's rights when they abandoned him and allowed him to leave school property. Such conduct shocks the conscience. And so it reads, this section reads as follows. The defendants acted recklessly and in conscious disregard of Ryan's rights and well-being when they left him alone and allowed him to wander off school property, knowing he would be unable to care for himself and suffer harm. The school district and staff members were aware Ryan had eloped on numerous occasions and thus had to be supervised at all times. Because defendants had notice of Ryan's past elopements and his disabilities, they were aware that leaving Ryan alone and unsupervised or allowing him to wander off school property was inherently dangerous to him. All right. Tammy Larson's attorneys also said the facts here also go a step beyond typical endangerment cases cited by the defendants, such as failing to investigate bullying by other students or preventing an assault by a third party. The district and staff members themselves, not other student or other actor, created the dangerous condition Ryan found himself in. Wow. Defendants left Ryan alone and watched him walk off the school grounds, unreasonably creating a risk of harm to Ryan. Their actions also caused Ryan to be in such a vulnerable position. Defendants had left Ryan alone and watched him walk off the school grounds, unreasonably creating a risk of harm to Ryan. So someone watched him walk off the school grounds without doing anything. Let's see here. there was another thing that just made me really sad. Okay, so this one states negligent infliction of emotional distress due to the actions of the defendant Larson, that's Tammy Larson, Ryan's mother, has suffered severe emotional distress following the disappearance and probable death of her son Ryan. To state a claim for negligent infliction of emotional distress under a bystander theory, a plaintiff must allege a seriously injured victim as a result of the proven negligence of the defendant, an intimate familial relationship with the victim, and emotional distress so severe that no person could be expected to endure it. Oddly enough, the defendants first argue that Larson has not stated a claim because she was not allegedly an injury to Ryan. Undoubtedly, the death of her son constitutes such a severe injury to state a claim. So they're just going back and forth on this, and I mean, I don't know how you can say that your child walking out of a school building and never to be seen again does not cause severe emotional distress. I mean, this is a head scratcher. So conclusion, Larson, individually and on behalf of Ryan, has adequately stated claims against the defendants for discriminating against Ryan in violation of the ADA and Rehabilitation Act, violating Ryan's rights under the IDEA and Fourth Amendment, acted in gross negligence when failing to supervise Ryan and causing Larson severe emotional distress. The defendant's actions in leaving Ryan alone and permitting him to walk off school grounds was a gross departure from professional judgment and conscious shocking. This court also has jurisdiction over all Larson's claims because she was not required to exhaust any administrative remedies, and defendants are entitled to any form of immunity. The court should deny defendant's motion to dismiss in its entirety. So, according to court records, I think that there was a stipulation document that I saw, and so the defendants, meaning the school district, will answer all of the things that were outlined in this document, and that is due, I believe, September 5th or 9th. I'll have to look at that, but it's somewhere in that time frame. So it'll be next month, and I will do another recording and give you an update on what this case is. The reason that I believe this case is important is because whatever, if it goes to trial, if it goes to trial, I believe the next step is discovery. So there's going to be evidence back and forth, and possibly the Jane Doe defendants 1 through 3 will be named. It looks like in the complaint that it's the lawsuit, the defendants are being sued in their individual as well as their official capacity. And so what that means is if there's any damages, I don't know how that works out, but there is a possibility that the school district will have to pay out some damages. And then there's a possibility, depending on the whoever is named in their individual capacity, there is a possibility that they may have to pay out, but there could very well be a chance of that. But yeah, I'm just going to update people on that, and if you have any questions or if you want a copy of this actual brief, I'll be happy to provide that for you. I can be reached at Loan, LOAN, .eby, so that's Edward Boy Yellow at gmail.com. So loan.eb@gmail.com. Thank you for listening to this recording.
Slowly wash away. Start filing today on Credit Karma, powered by TurboTax.
What's that? We don't have a motion to dismiss in the amended rules of civil procedure? Are you sure? Okay, let's find out.
Hello and welcome to another lecture video, and in this video I will talk about the motion to dismiss. If you have been following the amendments to the rules of civil procedure, you will notice a very ostensible and significant change, and that is on the motion to dismiss. So I call this video Whatever Happened to the Motion to Dismiss? And to that question, my quick answer is, it's not what you think. So let me explain. So first, a review. What is a motion to dismiss? A motion to dismiss is a legal pleading that asks a court to decide a case in favor of the pleading party because no legal claim exists, even if the facts are true as stated in the plaintiff. The motion to dismiss is used by defending parties who are trying to have a case thrown out in the early stages of litigation. Now, it's good if the motion to dismiss is granted because the case will be dismissed. Bravo for the defendant. But if the motion to dismiss is denied by the court, the Supreme Court has held that the order of the trial court denying a motion to dismiss is merely interlocutory, as it neither terminates nor finally disposes of a case and still leaves something to be done by the court before a case is finally decided on the merits. Therefore, the proper remedy in such a case is to appeal before a decision, after a decision has been rendered. In other words, once a motion to dismiss is denied, the defendant has to file an answer and just to proceed with trial and wait for the decision or the judgment in the case and raise the same arguments in the motion to dismiss as may be grounds for appeal. So some would say, a motion to dismiss would seem to be useless because if it's denied, you can't even appeal it. And so others would remark that a motion to dismiss is a delaying tactic for the defendant to prevent or stall the conduct of the trial. So with those observations, should we get rid of the motion to dismiss? Well, we are talking about the amendments. And these amendments, the 2019 proposed amendments to the 1997 Rules of Procedure, amended Rules 6 to 35 of the Rules of Civil Procedure. And they came to effect last May 1, 2020. And going through these amendments, you will notice this. Rule 16, motion to dismiss, is no longer there. And it's merely stated that the provisions are either deleted or transposed. Okay, so as the rules stand, you have Rule 15 and then Rule 17. There is no Rule 16. So what happened to the motion to dismiss? Well, the motion to dismiss is still recognized under the amended rules, particularly Section 5, Rule 15, and Section 12, Rule 15. Rule 15, by the way, is the rule on motions. So Section 5, Rule 15 provides the litigious motions, and litigious motions include a motion to dismiss. Now, under Section 12, Rule 15, you have the prohibited motions, and the following motions shall not be allowed. Accordingly, motion to dismiss is not allowed except on the following grounds. So in other words, if the motion to dismiss is not grounded on these three, then it will be denied outright. So choose your grounds wisely. So what are these exclusive grounds allowed for a motion to dismiss under the amended rules? Well, number one, that the court has no jurisdiction over the subject matter of the claim. So as you lawyers may well know, that a court's jurisdiction is conferred by the Constitution or by law. So it cannot be decided by the parties, or it is not subject to stipulation. So if the court has no jurisdiction over the claim, over the prayer, over the subject matter, then a motion to dismiss is proper. Also, another ground is that there is another action pending between the same parties for the same cause. And this is what we call litis pendentia. In other words, pending litigation. So the policy is that no two courts shall resolve the same case involving the same parties, involving the same causes of action, involving the same reliefs, okay, because of the possibility of conflicting decisions. And the practice of filing several cases in several courts is forum shopping. So forum shopping is, of course, prohibited, and so any act of forum shopping should be brought to the attention of the court, and so that is a ground for dismissing the case. Now, the third ground is that the cause of action is barred by a prior judgment or by the statute of limitations. Now, this ground is actually composed of two grounds. So first is res judicata, and the other one is prescription. So res judicata simply means conclusiveness of judgment. So what has been decided in the past with finality can no longer be tried again. Now for prescription, well, this only means that the claim is extinguished by the passage of time. Okay, so these are the three exclusive grounds for a motion to dismiss under the amended rules. So what happened to the other grounds recognized under the old rules of proceedings? And I am referring to the following. So that the court has no jurisdiction over the person of the defending party, that the venue is improperly laid, that the plaintiff has no legal capacity to sue, that the pleading asserting the claim states no cause of action, and that the condition precedent for filing the claim has not been complied with. These grounds have been used in the past, and they have succeeded, in having the claim dismissed. But then they're no longer recognized as grounds for a motion to dismiss under the amended rules. So what happened to them? Well, they are not entirely lost, because under the amended rules, they may only be raised as affirmative defenses in the answer. But there's a caveat. Failure to raise them as affirmative defenses at the earliest opportunity shall constitute a waiver thereof. So when preparing the answer, the lawyer should be aware and conscious of these grounds. And if facts are present to support any of these grounds, then the same should be argued in the answer as affirmative defenses. Otherwise, they are lost forever. Okay, so when allowed, meaning to say when the motion to dismiss is proper under the amended rules, how do we deal with this motion to dismiss? Well, first, because it is a litigious motion, movement must serve a copy to the other party, either personally, by private courier, by registered mail, or by electronic means. Now, the opposing party has 5 days from receipt within which to file a comment or opposition. So here, the period has been fixed by the rules. Instead of the opposing party asking for a period from, let's say, 5 days to as long as 20 days, subject to the discretion of the court, the period is already fixed. Now, the court, in its discretion, may call for a hearing on the motion. Now, this is important. In fact, this changes everything. Because before, a motion to dismiss should be set for hearing by the movant. At the end of the motion, there must be a notice of hearing. And the Supreme Court has invariably held that the failure to set the motion for hearing is fatal to the motion to dismiss. But now, it appears that the defendant is no longer required to set the motion for hearing. Just furnish the opposing party and then file it in court. Because after the receipt of the opposition, the court will determine if there is a need for a hearing. So clearly, it is the discretion of the court whether to set the motion for hearing or not. Okay, now finally, the court shall resolve the motion within 15 days from receipt of the opposition or from the expiration of the period to file said opposition. So clearly, the Supreme Court wanted to abbreviate and shorten the resolution of the motion to dismiss. So the motion to dismiss is still recognized, provided that the movement will follow all this procedure. So under the amended rules, the defendant can do either of the following to throw out the case in the early stages of litigation. So first, the defendant may raise affirmative defenses in the answer using the grounds for a motion to dismiss or those grounds which I mentioned, which are now good only for the answer as affirmative defenses. Now, also, the defendant may file a motion to dismiss based on the exceptional grounds, the three grounds which we mentioned earlier. Either way, if meritorious, the case may be dismissed by the court with prejudice. So clearly, the motion to dismiss is not totally lost to the defendant. The grounds are just minimized and are specified, while the others are placed as grounds for an affirmative defense in the answer. Okay, so that's where, or that's how the motion to dismiss has ended up after the amendments to the rules of civil procedure. So I hope this was helpful to you, and thank you for watching.
Doesn't work that way. Okay? Argument 3 was that there was no contract. False. ORS isn't, they said that, I mean, they literally admitted that there is no contract, and there was no contract that had been made through their non-response. And I said, okay, well, I mean, I'm gonna go that way in my next document, but if there's no contract, then what are you enforcing? If we don't know each other, then who the hell are you, you know? So anyway, no contract, false. ORS is enforcing something, but somehow they are an alleged party, and somehow a third party with no evidence of a claim can confiscate private property and use it to offset public welfare expenditures. And that's what they're doing. That's exactly what they're doing. And use a man for the surety for some legal scheme to engorge the state treasury with federal funding. It must be in contract with the private, so there must be a contract with this private man, and there is none. So, argument 4, constitutional claims, false. I have rights, and I have now, and I'll try to download and get this motion to dismiss. It's 15 pages of just gobbledygook, man. It's the same shit that they always send. Oh, we don't have to tell you nothing, and we're immune, and unless we consent, all that crap. It's just that they take case laws and they take a bunch of codes and statutes and try to throw them at you, even though we all know that stuff only applies to them. It doesn't apply to me. Okay? Show me the contract, motherfucker. Okay, sorry. Constitutional claims, false, because I have rights, and I have reserved all my rights. Most importantly, my right to contract and all presumptions and assumptions of joinder have been rebutted. Okay, we'll get to that here in a second. If ORS can force a contract, then I can force a contract, because all are equal under the law. This could have been avoided if they would just prove their claim. And then again, there was 4A and 4B. So ORS is a corporation. The state of Utah is a corporation. Salt Lake City is a corporation. For God's sakes, it says it on the side of their vehicles. And that's true. It actually has their seal on the side of their trucks and their park and recreation vehicles and all their guys that, are downtown doing maintenance and all that. It says Salt Lake City Corporation on it, okay? State of Utah is a corporation. We all know that, okay? There is no de jure government anymore. So you're all corporate, okay? Commercial contractors. Black's Law Dictionary clearly defines persons as corporations, businesses, trusts, and operating equity. They are single and separate, and a 1983 case is reasonably plausible. So that will probably be the next one, because I'm going after everybody in their individual capacity. So ORS is not the real de jure government. Conclusion. Douglas Richamumi is a private trust. There's my UCC filing number if you want to look it up. Colorado State includes an unrebutted superior claim on all property of the trust. Affidavits. These are filed with the Salt Lake County Recorder's Office under miscellaneous. There is a estoppel at law, nunc pro tunc. Okay, I rescinded all their authority for lack of full disclosure. There is an affidavit of truth and an affidavit of sovereignty. Okay, they're all filed with Salt Lake County Recorder's Office, presented as evidence with this judicial notice of precedent as Exhibit XYZ. Okay. A security agreement between myself and the trust is recorded, and any infringement is subject to the terms. I have control of my assets. I have control, okay? You don't own anything, you control everything, okay? David Rockefeller said that. Put everything in a trust, and you control the trust. You become the trustee, you become the controlling manager. My labor, my trust, my life, my property, and unless ORS is a registered claim on me or the trust, they are operating outside their jurisdiction. And hopefully they will come into court and say, well, we have a claim, and it's filed with the 3rd District Court, because I happen to know that they have one of these secret little filings that they do that's an in-house lien that they put on you, and they don't put it out in the public. It's private. Okay, because they're private corporations. Okay, so ORS and the 3rd District Court are a couple of scumbags who do this private. I got an email, man. I'll show you the email one of these days. But it's basically the court clerk saying we have a judgment against you, which is a lien. Okay, it's a lien, and it's not against me. It's against the all cap name. So they're attacking property that does not belong to them and have not provided the secured party trustee with any evidence of a debt. Therefore, having addressed this motion, I respectfully move this court to protect the private rights of this man and deny this motion to dismiss. I would also ask this court to review my administrative process, confirm its validity, and the coming motion for summary judgment should be granted. Notice of request for a hearing to unpack any questions should be granted if you need it. Okay, I'm willing to go in there and just mob on them again. So, plus I want to go back to court anyway. I need some more experience in court. And so, yeah, the more you go to court, the more experience you get. So,
Treating yourself without cheating your goals. Eat smart with Factor.
Deal can hire, manage, pay, and develop a global workforce, all while staying compliant.
Hi, everybody. This is App to Dismiss. We're going to discuss when the magistrate judge recommends dismissing the plaintiff's complaint and how to object. And to demonstrate this process, I'm actually going to go over a sample objection of a real case. So let's get started. So let's talk about the magistrate's findings and recommendations and what that process really involves. After the defendant files their motion to dismiss and the plaintiff responds, the district court judge submits it to the magistrate court judge for review. The magistrate judge reports his or her findings and recommendations to the district court judge. And you can find this at Federal Rules of Civil Procedure 72B1. After the plaintiff receives the magistrate judge's report and recommendations, the plaintiff will have 14 days to object in writing. You can find this in Federal Rules of Civil Procedure 72B2. So let's talk about some reasons why a plaintiff would file objections. For one, it's the plaintiff's right, and that right is addressed in Federal Rules of Civil Procedure 72B2. Another reason is the magistrate's findings are not the last word. The judge makes the final decision. And you can find that in Federal Rules of Civil Procedure 72B3. Now, if you've been watching my videos, you know I am big on facts. It is the facts that help make the plaintiff's case. So that's another reason why a plaintiff would object. When the facts are on the side of the plaintiff. Federal Rules of Civil Procedure 8A2 is clear that the plaintiff must present short and plain statements. That is, the statement must present facts that are plausible. And if you reviewed my video a couple of weeks ago, I talked about plausibility facts. State the facts. The next reason is that the law is on the side of the plaintiff. Now, the plaintiff must be able to identify the law they're relying on in order to tell the court what their demand is. Federal Rules of Procedure 8A3 requires the plaintiff to state the demand for relief sought. So in some way, the plaintiff needs to make that known in the complaint. Some time ago, I uploaded a video on how the complaint is constructed and how it includes the law that the plaintiff relies on in making their case. The law is on the side of the plaintiff. Another reason why the plaintiff would object is that they can bring the complaint into compliance. What am I saying? Let's say, for example, that the plaintiff misstated a law or cited the wrong law. And there is an actual law that supports the plaintiff's case. Well, the plaintiff could move to amend the complaint to bring it into compliance with the law. Federal Rules of Civil Procedure 15 covers amending complaints. Another reason why the plaintiff would object. By filing the objection, the record is preserved for appeal. And here's my motto. If a party believes that their case has plausibility, be prepared to take it to the United States Supreme Court. If the facts are there, if the law is there, be prepared to go all the way. Federal Rules of Appellate Procedure 30.
At the beginning of the video, I told you I would go over a real objection and show you how it's done. Well, that's what we have here. We're going to look at the structure of the objection that the plaintiff could actually use in constructing their objections. This lawsuit has been filed by Electronic Privacy Information Center against Federal Bureau of Investigation. So let's go through the structure and demonstrate how it's done. So the information you see here highlighted in yellow, the plaintiff could actually use this language to begin their objections because it's real language, which can be found in Federal Rule 72. Now, of course, the information not highlighted here, the plaintiff would have to tailor it to their case, and also they would have to include the dates that are applicable to their case. Now, notice that this plaintiff, Epic, objects to 3 of the magistrate's recommendations. And I put little notes in this presentation ahead of time so that I can discuss each of them. So here plaintiff identifies the recommendations that they object to. Objection 1, objection 2, and objection 3. My note here says that Epic states all 3 recommendations were based on errors of fact and are contrary.
Hey, you can't do that.
What?
Jules.
To law. Now what Epic must do and will do is present the facts and the law supporting their contention here. The next thing Epic does here is address the standard or state the standard of review to show by the judge. Look at my note here, state the law and the local rules in the jurisdiction the lawsuit is filed in. And that's what Epic did here. They state the local rule 72.3c provides that a district judge shall make a de novo determination of those portions of a magistrate judge's findings and recommendations, paragraph B, and so on and so forth. Now, of course, the plaintiff wants to cite the local rules in the jurisdiction in which their lawsuit is filed. Now, let me say this. In making these objections against the magistrate judge, in no way disrespects the magistrate court judge, nor does it disrespect the district court judge. The plaintiff is simply making his or her case. They have that right to do that. And they should use every tool available to them to make their case. We'll look at each of those 3 objections individually. Epic is entitled to full attorney fees for the time spent drafting and filing the complaint, reviewing documents, and litigating the fees issued. Now remember, some time ago I did a video on mirroring the defendant's motion to dismiss, in this case, the magistrate judge's findings and recommendations. So let's look at my little note here. This is Epic's first objection. And it sounds like the magistrate judge recommended that the district court reduce fees plaintiff asked for in their complaint. Because we don't have report and recommendations. We can tell from the plaintiff's subheading here that the magistrate judge recommended that the district court reduce fees plaintiff asked for in their complaint. Because plaintiff's subheading says the magistrate's recommendation regarding the fee reduction for the complaint is logically impossible. Epic spent a reasonable amount of time drafting the complaint. That's what we mean by mirroring. Make it easy on yourself, plaintiff, and just mirror what the defendant wrote, in this case what the magistrate court wrote, to refute what they wrote. Here is an example of Epic refuting what the magistrate judge wrote. Epic's, first let's look at my notes. Epic's provided facts that support their objection and shows the court where the evidence can be found in the record. Epic's attorney spent 18.4 hours researching, drafting, editing, and finalizing the complaint and filing associated documents. They're refuting, right? They're mirroring. They refuted what the magistrate judge wrote. And they told the judge where they can find the evidence to support their argument. And that would be the underlying information here. Let's move on. Let's see what my notes say here. Plaintiffs continue to argue the first objection and cites case law. And that's what we have here. So Epic is arguing neither the FBI nor the magistrate can cite a single case that supports the conclusion that this is an unreasonable amount to bill for preparing and filing a complaint. And courts in this circuit have previously rejected such minute objections to fees for work done of a specific element of a FOIA. And what they've done is cited case law. And you see the importance of citing case law and providing facts that can be located in the record to support the plaintiff's objections. Do you see that? All right, let's go on. This is Epic's second objection. And let's see what my note says. Objection 2. See how plaintiff continues to mirror the judge's findings. Apparently, the judge found plaintiff's attorney spent too much time on reviewing documents. Epic wrote, Epic is entitled to bill for time spent reviewing documents as a necessary part of this litigation. Again, I call this mirroring. Let's see what the note says. Again, plaintiff supports their argument with evidence and cites where the evidence can be found in the record. Epic stated here, Mr. Butler spent a total of 11.1 hours on intake and review of the 4,377 pages of documents released prior to the August 2013 Joint Status Report. Epic tells the court what evidence supports their argument and where that evidence can be found. The motion bill at 8 through 12 Joint Status Report, ECF is electronic record number 23 at paragraph 8. See what my note says? Plaintiff objects again by citing a case that supports their argument. Plaintiff says, courts in this circuit have held that plaintiffs may be compensated for time spent reviewing documents produced during the course of the litigation, and they cite case law here. The underlying information is case law. Let's move on.
Cascade Platinum Plus gives you the highest standard of clean, even in your machine. Dare to dish differently.
If you're unsure or unaware of your eyeglass prescription, or if your prescription changes frequently due to nearsightedness or farsightedness, then the Smart Zoom reading glasses are perfect for you. They automatically adjust from 100 to 700 diopters, developed in collaboration with the DOGbackwardsss team. These glasses are suitable for both farsightedness and nearsightedness, also known as Professor Thomas, who spent 10 years developing this new model. You don't need to undergo expensive eye tests at specialized stores. In just 1 second, you can go from blurry to clear vision. You'll experience clear views once again, and they filter out 90% of radiation and blue light from electronic devices. These glasses allow you to look at your phone, watch TV, or read all day without feeling fatigued. They can also be used as sunglasses and provide 360-degree comprehensive protection. We guarantee today's national lowest price, and if you're not satisfied, we offer a triple refund. Whether you're buying them for yourself or as a gift for your parents, they're an excellent choice. With a 10-year warranty. Click the link to purchase now.
Objection 3. Epic is entitled to recover fees on fees. Apparently, the judge found plaintiff's request for fees is not compensable in a FOIA case, a Freedom of Information Act case. Plaintiff argues they are compensable, and plaintiff cites case law. Plaintiff states courts in this circuit have repeatedly held that hours reasonably devoted to a request for fees are compensable in a FOIA matter, and they cite case law. Plaintiff again presents evidence to support their argument. The magistrate also recommended deferring on a decision with respect to fees on fees until the trial court's final determination of fees and accounting for the hours spent in litigating fees. You see here where, again, it tells the court where it can be found. Report at 13 through 14. Finally, let's see with this last note. The plaintiff continues its objection regarding deferring fees on fees, and they cite law supporting their position. Epix wrote, second, the magistrate's recommendation that Epic's fees on fees should be deferred has no basis in fact or law. Now you see what they're arguing here is that the court erred in the law and they erred in facts. And Epic's cite cases to support their argument. Epix objects to the error of facts and the recommendation that are contrary to law in the magistrate's report. That's really important. So they're outlining or highlighting what they present as the magistrate judge's errors of the fact and the law. Sign the objection and don't forget the certificate of service.
I trust this has been helpful to you. And as always, and Advocate Lucinda be empowered.
You know what's smart? Truffle butter filet mignon without lifting a finger. Eat smart with Factor.
Adobe Acrobat AI Assistant helps me build trust with clients. With AI Assistant, I can find contract details quickly. Having all of this together helps position myself as an expert, and it gives me that confidence to talk to clients.
What factors should one consider when deciding how to file a motion to dismiss? What techniques should the individual use to maximize its persuasiveness, and ultimately the likelihood of success on the merits? We'll look to answer those questions, provide writing tips to ensure that a motion to dismiss is well written and persuasive, and offer an example of a motion to dismiss. A motion to dismiss is a powerful weapon in a defendant's arsenal. It protects clients against non-meritorious lawsuits, promotes judicial economy, and facilitates the speedy resolution of frivolous cases. In federal court, the motion to dismiss is governed by Rule 12b of the Federal Rules of Civil Procedure, which provides specific grounds upon which a person can move to dismiss a complaint. Under federal law, and in most jurisdictions, one can move to dismiss a complaint for the following reasons, among others: lack of personal jurisdiction, lack of subject matter jurisdiction, improper venue, improper service, and failure to state a claim upon which relief can be granted. A defendant can seek to have a complaint dismissed for more than one reason, such as lack of service of process and failure to state a claim upon which relief can be granted. One can also move to dismiss the entire complaint or only specific causes of action. Of course, if the defendant is only asking the court to dismiss certain claims, those claims must be specified. Ultimately, a defendant should think thoroughly about the likelihood of success before filing a motion to dismiss, and should not include weak or substandard arguments, as they will likely detract from the strongest arguments. Judges review motions to dismiss with exacting scrutiny. Notwithstanding that, motions to dismiss are granted regularly, demonstrating that they are clearly appropriate in some cases, and the quality of the writing directly affects the chance of success. After deciding to file a motion to dismiss, while drafting it, a defendant should adhere to the following suggestions and guidelines to write the most effective and persuasive motion possible. 1. Write a short and clear introduction. 2. Draft a factually accurate narrative. 3. Know the standards that must be met and craft an explanation of the standards. 4. Use the most persuasive components of the relevant law. And 5. Apply the law to the facts in a convincing and credible manner. Let's start with the introduction. An introduction does not need to be long-winded, but should provide some general facts and analysis and let the court know that the motion seeks dismissal of the plaintiff's complaint. In the introduction, one can choose to discuss the applicable legal principles. Since a defendant will provide citations and cases and statutes and other authorities later in the motion, it's not necessary to provide them in the introduction. Courts deal with motion to dismiss frequently, so one should in most instances omit a detailed explanation of the law in the introduction of the motion to dismiss. However, the introduction should at least mention the applicable law. Below is an example introduction where the defendant is moving to dismiss a complaint for lack of subject matter jurisdiction. Long Construction Company files this motion to dismiss, asking the court to dismiss Eastern State's complaint for lack of subject matter jurisdiction. Eastern alleges that the court has subject matter jurisdiction over this case pursuant to 28 United States Code Section 1332, which vests a federal court with jurisdiction over state law claims when there is diversity of citizenship. While the defendant admits that the amount in controversy exceeds the $75,000 statutory minimum, the defendant and the plaintiff are not citizens of different states. Thus, there is no diversity of citizenship. Long and Eastern, the plaintiff and defendant, are both citizens of Virginia. Long is a Delaware corporation, however, its principal place of business is in Virginia, and Eastern is a Virginia corporation with its principal place of business in Virginia as well. Because Long and Eastern are both residents of Virginia, this court lacks subject matter jurisdiction. Thus, Long's motion to dismiss should be granted. This introduction tells the court that Long wants a dismissal, tells the court the facts that support Long's motion, namely that Long and Eastern are citizens of the same state, tells the court what law Long is relying on without going into great detail about the law, since federal courts know the requirements of Section 1332, and reminds the court again what Long is asking the court to do. Introductions are extraordinarily helpful for judges and their clerks, and people should use them in every motion. The second category is to draft a factually accurate narrative. With the very important exception of motions to dismiss for failure to state a claim, statements of facts in motions to dismiss are not that important. Under the federal rules, the court must assume that the allegations in the complaint are true. Thus, in the motion to dismiss, one can still briefly outline the factual contentions in the case, but one should not dispute that they are true for purposes of a motion to dismiss. What one must do in the statement of fact is to include facts that will be used in the brief to support the motions to dismiss. Many times these facts will have nothing to do with the substance of the complaint. For example, the necessary supporting facts might be the client's state of incorporation or the amount in controversy, if the issue is subject matter jurisdiction, or the client's state of residency if the issue is personal jurisdiction, or that the client has not been served with process if the motion is based on lack of service of process. Importantly, for each fact offered in the statement of facts, one must cite the complaint or some other admissible evidence that supports that position. Now we'll look at an example of an effective statement of facts. Suppose one represents a defendant corporation and wants to file a motion to dismiss the plaintiff's personal injury action based on lack of service of process. The plaintiff attempted to perfect service on the client by serving the corporation's president's administrative assistant. But that person has legal authority from the jurisdiction that service on an administrative assistant who is not authorized to accept service is not sufficient. So how might these facts be presented? Here's an example. Dean filed this personal injury action against Jackson Management Company on July 15, 2017, just one day before the 2-year statute of limitations expired. On July 28, 2017, Dean attempted to perfect service on Jackson by delivering a copy of the summons and complaint to Elizabeth Ronald, the administrative assistant of Jackson's president, Ryan Winston. And here the affidavit of Ronald could be cited. That day, Dean's process server, who did not identify himself as such, entered Jackson's headquarters and asked Ronald if she worked for Winston. When Ronald told the process server that she did work for Winston, he handed her the envelope and walked out of Jackson's office. In fact, Ronald was not even aware that the Dean's process server was attempting service until Ronald opened the package, which bore Winston's name, saw the summons and complaint. Ronald is not an officer of Jackson Corporation and is not Jackson's registered agent for service. Ronald had no authority to accept service of process on behalf of Jackson and did not represent to the process server that she had such authority. Out of an abundance of caution, Jackson filed an answer within 30 days of the date that Jackson was purportedly served. This would be an example of a statement of facts and would cite appropriate authority, such as the complaint or other affidavits, for all of the assertions of fact. Now, this passage contains very little information about the underlying factual allegations. In fact, the only information the reader learns is that the suit is a personal injury action. However, that's because the allegations in the complaint are not important for purposes of Jackson's motion to dismiss. The only facts that matter are those that bear on the issue of whether service of process on the administrative assistant was valid service. So those are the only facts that the writer outlines. Jackson's decision not to mention the underlying allegations is also a strategic one. Jackson wants the court to focus on the plaintiff's bad conduct in waiting until the last minute to file the complaint, and then failing to properly perfect service, not the bad conduct that Jackson has allegedly committed that injured the plaintiff. By declining to detail the underlying facts, Jackson seeks to avoid giving the court a reason to feel sorry for the plaintiff and allow him another opportunity to perfect service. If, on the other hand, the motion to dismiss is for failure to state a claim upon which relief can be granted, then the underlying allegations are critically important. Why? Because in filing a motion to dismiss, the filer basically says, for purposes of the motion, I'll concede that everything that you say are true. But even if they are, the plaintiff still can't state a claim. Therefore, an allegation of the facts and an in-depth analysis of those facts showing why they do not establish a legitimate cause of action are very important. Next, let's look at the standard that has to be met when filing a motion to dismiss. The standard for granting a motion to dismiss is high. One must know what needs to be proved to show that the client is entitled to a dismissal. In so doing, one must present the law honestly, but should also state the standard in a way that favors the client's position. Here's an example of how this can be accomplished for a motion to dismiss for failure to state a claim. Note that the motion to dismiss should cite authorities, such as cases or statutes, whenever appropriate. So here's the example. To survive a motion to dismiss under Rule 12b-6 of the Federal Rules of Civil Procedure, the complaint must state a claim of relief that is plausible on its face. A motion to dismiss should be granted when the plaintiff can prove no set of facts in support of the plaintiff's claims which would entitle the plaintiff to relief. The Seventh Circuit Court of Appeals has interpreted this standard to mean that, to survive a motion to dismiss for failure to state a claim, the plaintiff's complaint must contain either direct or inferential allegations respecting all material elements necessary to sustain a recovery under some viable legal theory. Grant of a motion to dismiss pursuant to Rule 12b-6 serves the very valuable function of saving judicial and party resources in cases where it simply would not be productive to proceed.
Need a snack that satisfies? The snack heroes are here to punch things up with the big flavor of Baby Bell. Baby Bell, join the goodness.
If every claim were allowed to proceed to trial, the cost generated thereby would be enormous, and there would be little benefit in the way of increased accuracy of the results. When it's obvious well before trial that the defending party is entitled to judgment, there's no need to expend further resources of the parties and the court. This is an example of a good defendant-friendly explanation of the general standard. Instead of focusing on what the defendant must prove to get the motion granted, the author dressed the standard in terms of what the plaintiff must prove to survive the motion, making it subtly appear like the plaintiff bears the burden of proof. The author uses the following language: to survive a motion to dismiss, the complaint must. A motion to dismiss should be granted when the plaintiff, etc., and the plaintiff's complaint must. What does that paragraph add to the explanation of the standard? A lot for the defendant. The author uses the second paragraph to emphasize the importance of 12b-6 motions, and is essentially saying to the court, I'm helping you out by filing this motion. I'm trying to preserve judicial resources, avoid wasting money, and prevent this fruitless case from clogging up the court docket. Good legal writers start with a broad explanation of the relevant legal principles, which is often known as the umbrella section, and work their way to more specific explanations of the law. One should use this same method when drafting the authority and analysis section of a motion to dismiss, and should focus on the law that is favorable. For this section, we're going to focus on the Virginia Diversity of Citizenship case that we discussed a little bit earlier. How should the law be outlined, in which the individual begins with broad principles and gravitates to more specific ones? Here's an example. Federal courts are courts of limited jurisdiction, and the burden of proving jurisdiction rests with the party asserting it. When the plaintiff seeks to litigate a state law claim in federal court, the plaintiff must prove that the federal court has subject matter jurisdiction pursuant to 28 United States Code section 1332. Under that statute, a federal court has original subject matter jurisdiction over litigation, 1, where the amount in controversy exceeds $75,000, excluding interest and costs, and 2, the parties are citizens of different states. And then, of course, you would cite Section 1332. A corporation is deemed to be a resident of both the state in which it is incorporated and the state in which its principal place of business is located. Thus, Section 1332C provides dual, not alternative citizenship to a corporation that is incorporated in one state and maintains its principal place of business in another. A corporation's principal place of business is its nerve center, that is, the place where a corporation's officers and other management direct, control, and coordinate the corporation's activities. The nerve center is the location of the corporation's headquarters, so long as that headquarters is the actual center of direction, control, and coordination. In determining a corporation's nerve center, courts will look to the location of the corporate oversight and strategic decision-making. The principal place of business analysis is performed on a case-by-case basis. For example, in the Central West Virginia case, the Fourth Circuit Court of Appeals considered whether a defendant's principal place of business was located in Michigan or West Virginia. The offices of the defendant's CEO, COO, CFO, and General Counsel were in Michigan, while only one corporate officer, who was a vice president and general manager, maintained a West Virginia office. The Michigan officers were responsible for significant oversight and strategic decision-making, but the day-to-day company management and operations, such as purchasing materials, selling products, and administering payroll, occurred in West Virginia. The defendant's corporate filings in several states, including West Virginia and Michigan, listed Michigan as the company's principal place of business. The Fourth Circuit held that the defendant's principal place of business for purposes of Section 1332 was Michigan. The court held, under the Hertz test, that the defendant's principal place of business was Michigan because the corporate policies were set in Michigan, high-level corporate decisions were made in Michigan, and corporate oversight occurred in Michigan. The court acknowledged that the employees who made day-to-day decisions were located in West Virginia, and that the company was active in West Virginia business community. However, the court held, under the Hertz analysis, that the defendant's nerve center was in Michigan. And here we cite another case, Kansas City Life Insurance Company versus Citicorp, for the proposition that the company's principal place of business was Missouri, where the CEO's office was located in Missouri, and the board of directors meetings were held there as well. In this example, the author outlines the broad subject matter jurisdiction principles, namely, that federal courts are courts of limited jurisdiction, then focuses on the elements of federal subject matter jurisdiction analysis, namely, the amount in controversy and diversity of citizenship of the plaintiff and defendant, and explains how courts determine citizenship of corporations, and then offers a case illustration of how courts apply that test. Finally, we have to apply the law to the facts in a convincing and credible manner. The legal arguments in a motion to dismiss must be extremely persuasive and supported by relevant facts. If the court has any doubts about one's entitlement to dismissal, those doubts will be resolved in the plaintiff's favor, and the motion to dismiss will be denied. Thus, the authority and legal analysis sections of the motion to dismiss are very important. Additionally, the analysis must consist of more than just a conclusory summary of the facts, or a blanket statement that the statutes or cases cited support the position. The analysis should answer the question, why should the client prevail in light of the facts and law? Some of the questions that one should ask to guide this analysis are, why is a statute or regulation applicable or inapplicable? How are favorable cases similar to our case? Does a comparison between recent cases and older cases suggest a trend that supports our legal argument? How are unfavorable cases factually distinguishable from our case? Was an unfavorable case decided under a different statute with different language? Was an unfavorable case decided under common law principles, but a statute now applies? And are there policy arguments that support the position or disfavor the adversary's position? In addition, while we should not be overly repetitive, we should err on the side of over-explaining rather than under-explaining. Here's an example of an effective legal analysis of the Virginia subject matter jurisdiction case. In this matter, the requirements of Section 1332 are not met, and this court has no subject matter jurisdiction over this case. Long admits that the amount in controversy exceeds the $75,000 statutory minimum. However, Long and Eastern are not citizens of different states, and therefore there is no diversity of citizenship between the parties. Under subsection C1 of Section 1332, Long, a corporation, is a citizen of both the state in which it was incorporated and the state in which its principal place of business is located. Long was incorporated in Delaware and thus is indisputably a citizen of Delaware. However, Long is also a citizen of Virginia, because under the Hertz Nerve Center test, Long's principal place of business is in Virginia. As outlined above, Long maintains a small office in Delaware that serves as a central call center for the company, and Long's accounting operations occur in Delaware. 8 of Long's 300 employees work in the Delaware office, but not one of those 8 employees has any decision-making authority. Long's headquarters is located in Roanoke, Virginia. The office of Long's owner and president, the single person who makes all corporate-level decisions and has sole control over the operation of the company, is located in Roanoke, Virginia as well, and even the day-to-day operations of the company occur in Roanoke. Further, Long's corporate filings, with the Secretaries of State in both Delaware and Virginia, list Long's Roanoke, Virginia address as its principal place of business. There can be little question that Roanoke, Virginia is the place where Long's owner and president directs, controls, and coordinates Long's activities. Evidence that Long's principal place of business is in Virginia is even stronger than the evidence presented in the Central West Virginia case. In the Central West Virginia case, the defendant's officers, who were responsible for company oversight and strategic decision-making, were located in Michigan, but the day-to-day operations occurred in West Virginia. Here, Long's headquarters and president, the single decision-making authority in the company, are both located in Virginia, and Long's corporate filings represent to all interested parties that its principal place of business is in Virginia. And, unlike in Central West Virginia case, where day-to-day operations and decision-making occurred in different states, the vast majority of all of Long's company's operations, including day-to-day operations, occur in Virginia. Under the Hertz Nerve Center test, Long's principal place of business is located in Virginia, and Long, therefore, is a resident of the state of Virginia. There is no question that Central, the defendant in the case, is a Virginia resident, because Central's state of incorporation is in Virginia. As outlined above, Long is also a Virginia resident because its principal place of business is there. Thus, because Long and Central are both citizens of Virginia, there is no diversity of citizenship between them, and the requirements of Section 1332 are not met. Therefore, this court lacks subject matter jurisdiction over this matter, and Long's motion to dismiss should be granted. The author of this section effectively analyzes the legal issue in light of the facts, and answers the question, why should Long prevail in light of the facts in law? Specifically, the author begins the analysis by summarizing the relevant facts about Long's corporate structure and the location of its headquarters to reach the conclusion that Long's principal place of business is in Virginia under the Nerve Center test. The author then compares and contrasts the facts to those in the Central West Virginia case, explaining how the facts are similar to, and even stronger than, those present in the Central West Virginia case. Importantly, the author concludes the analysis by answering the initial question, is there subject matter jurisdiction? The author explains that the court lacks subject matter jurisdiction because Long is a citizen of Virginia, because its principal place of business, per the Hertz Nerve Center test, is located there, and because Central, the other party to the case, is also a citizen of Virginia because it's incorporated there. Because the legal analysis section is such an important part of any brief, or memo, or motion, one must be sure that the legal analysis is thorough and convincing. Practicing applying these techniques, including correctly drafting facts, standards, law, and then applying the law to the facts, is the best way to improve one's writing skills. It will also help improve the persuasiveness of the person's writing,
and that person's likelihood of succeeding on the merits will be maximized.
Refresh the everyday with Mentos Gum. Yes to fresh.
Working in law enforcement and in juvenile detention centers, I got to see the back end of it, like how kids are getting here, but I wanted to see the front end in a sense. I would say to anyone who's looking to further their career with GCU, take a leap of faith and just trust the process. Stepping from one career into the next, that purpose that I was looking for, GCU literally brought it front and center. GCU was able to give me all the help and support I needed to graduate and reach my professional goals.
Verbal and written statements are commonly offered at hearings and trials to prove facts at issue in a case. Courts are required to exclude certain statements from evidence when they were made by parties not present to testify at the trial or hearing. These statements are referred to as hearsay. The types of statements that are excluded as hearsay include a person's oral assertion, written assertion, or nonverbal conduct that is intended as an assertion. A head nod, for example, is nonverbal conduct that is also an assertion. The party that originally made the statement or assertion that is being offered as evidence is referred to as the declarant. Hearsay is 1. A statement that the declarant makes other than while testifying at the current trial or hearing, and 2. That is offered to prove the truth of the matter asserted. Anytime a witness testifies as to what another person said and offers it as proof that what the other person said is true, then that evidence is being offered to prove the truth of the matter asserted. For example, let's say that in a family law case, Henry wants to testify that his wife's mother, Mother May, stated that she saw the wife, Wendy, hit her child. Since Henry is testifying as to what Mother May said, the testimony could be hearsay. If Henry is offering Mother May's statement as proof that Wendy hit their child, then it's hearsay. Henry is not the proper person to testify as to what Mother May said. Mother May should herself testify as to what she observed. On the other hand, suppose Henry is offering Mother May's statement to show that Mother May and Henry communicate regularly about the child. For example, what if Henry wants to support his claim that Mother May is an appropriate temporary guardian for the child, and therefore wants to establish that she takes an interest in the child and discusses the welfare of the child on a regular basis. Henry is no longer trying to prove that Wendy actually hit the child. Since Henry is not offering this statement as proof what Mother May said is true, the statement does not meet the definition of hearsay. It's being offered, essentially, to show that the conversation took place. The substance of the conversation is not really relevant to that point, and it's not critical to determine whether the statement that Wendy hit the child is actually true to establish what the testimony is trying to prove. Therefore, this statement is not being offered for its truth value and is not hearsay. One nuance to the hearsay rule is that statements made by the opposing party in the current case are not hearsay. These statements are referred to as admissions of a party opponent and are admissible in court so long as the admission is being used against the opposing party. Thus, if Wendy ever admitted to hitting the child in the previous case, Henry could introduce Wendy's admission into evidence and use it as proof that she did in fact hit the child. This, incidentally, is why confessions made to police officers by criminal defendants are admissible at trial, even though, technically, they're hearsay. Many exceptions to the hearsay rule exist to allow certain statements to be admitted as evidence. Some exceptions apply only when the declarant is not available to testify as a witness. However, most exceptions apply regardless of whether the declarant is available. Thus, for example, any of the statements that meet these exceptions are admissible even when the witness is not the declarant, and even when the declarant can be theoretically brought to court to testify. Let's take a look at some of these exceptions. Present sense impressions are statements that explain an occurring event or condition. These statements are made while the declarant perceives the event or condition, or immediately thereafter. For example, a witness may properly testify to being a passenger in a vehicle and hearing the driver say, "I'm driving way too fast right now," because this statement was made while the driver was perceiving the driving. The next exception is an excited utterance. An excited utterance is a statement relating to a startling event or condition made while the declarant was under stress of excitement that it caused. A witness screaming, "Oh my gosh, that car ran a red light," directly after observing a car accident, is an example of an excited utterance. However, if the same witness makes this same statement 5 days later, for example, then the statement was not made under the stress of excitement from the accident and is therefore not an excited utterance. The third exception is a statement of a then existing mental, emotional, or physical condition, which expresses the declarant's then existing state of mind. The statement may express motive, intent, plan, emotion, sensory perception, or physical condition. This exception does not apply to a statement expressing a memory or belief. Just like the present sense impression and excited utterance exceptions, a statement of a then existing mental, emotional, or physical condition must be made close in time to the related event or condition. A statement such as "I am scared" expresses a state of mind. The statement "I remember being scared when the dog approached me" expresses a memory. Therefore, the first statement is considered an exception to the hearsay rule, while the second is not. These first three exceptions are collectively sometimes known as the res gestae exceptions. It's as though the event is speaking through the statement, since the statement is being made at the time that the event is ongoing. Exception 4 is a statement made for medical diagnosis or treatment. This must satisfy two requirements. First, the statement must be made for and reasonably pertinent to a medical diagnosis or treatment. Second, the statement must describe medical history or past or present symptoms or sensations, their inception, or their general cause. This exception is broad, and the statement does not need to be made directly to a medical provider, nor does the witness need to have medical training. Witness testimony that the declarant stated, "I have a back pain, and my back's been hurting for about 5 years," to a hospital staff member, for example, falls within this exception. The next exception is made for records of regularly conducted activities, and is commonly known as the business records exception. This exception is used to admit written statements of an act, event, condition, opinion, or diagnosis. The record must be made at or near the time of the act by someone with knowledge of the information in the record. The record also must be made and kept as part of a regularly conducted activity of a business, organization, occupation, or calling. Unlike the other exceptions we've discussed so far, in order to admit evidence under this exception, the testifying witness must be someone who's responsible for keeping the records, or be otherwise qualified to testify as to how and why the records were kept. For example, in a mortgage foreclosure case, a lender may want to admit mortgage documents into evidence. The mortgage documents themselves would be considered hearsay, because they were written by somebody not here testifying in court right now. They're hearsay, that is, unless the lender provides an employee who has the job of maintaining the mortgage records. The employee must be able to testify that the record was made near the time of the mortgage, or near the time that the mortgage was created, and that the record was kept as part of the regular course of business. Police reports are another common example of a business record. However, a statement from a witness contained within a police report may not necessarily be admitted simply because the report itself qualifies as a business record.
Attention super markup shoppers, just a heads up. These loyalty cards with exclusive deals, it's a sham. At Aldi, you don't need one. You just walk in and save. That's why they're #1 in everyday low prices.
It's an Aldi thing.
Maya knows how quality care can bring out a smile. But it's been a few dog years since she was able to enjoy a smile of her own. Good thing Aspen Dental offers affordable complete care all in one place. And new patients without insurance get $29 exams and x-rays. Plus 20% off treatment plans for everyone. Loving our patients unconditionally. It's one more way. Aspen Dental is in your corner.
Come and get your love.
This presents the problem of hearsay within hearsay, where the hearsay document, or the report, which is admissible, contains another layer of hearsay, which is the statement from the witness that was written down by the police officer. Each layer of hearsay will need to fall within an exception. For example, a witness may make a statement in a police report while still under the excitement of the event covered in the report. In that case, the police report can be admitted as a business record, and a statement from the witness can be admitted as an excited utterance. Until now, we've been discussing exceptions that apply whether or not the witness is available to testify. There are some exceptions that require the unavailability of the declarant in order to work. Regarding these exceptions, a declarant is considered unavailable when one of the following applies. 1. A court rule or privilege prevents the declarant from testifying. 2. The declarant refuses to testify after a court order has been issued. 3. The declarant testifies to not remembering the subject matter. 4. The declarant cannot testify because of death, infirmity, or physical or mental illness. Or 5. The declarant is absent from the trial or hearing, and the party seeking to present the declarant has not been able to ensure the declarant's attendance. We will discuss 2 of these exceptions. The first exception requiring unavailability is for statements made by the declarant under the belief that death is imminent. These are commonly referred to as dying declarations. The declaration should be about the cause or circumstances of the declarant's death. If, for example, a victim is shot in the chest and yells, "Brian shot me," this statement may be a dying declaration, because the declarant could reasonably believe that death was imminent after being shot. Finally, a statement against interest of the declarant is another exception that can be used when the declarant is unavailable. This refers to a statement that is so contrary to the interests of the declarant that it must be true. The statement can expose the declarant to liability or jeopardize a financial or ownership interest. The idea is that no reasonable person in the declarant's position would have made the statement unless the person believed the statement to be true. Such a statement could include a driver apologizing to another driver for causing an accident, or the declarant's admission to another person that the declarant owes that person money. Since the statement exposes the declarant to liability, a reasonable person would not make that statement unless believing it to be true. The common thread throughout the exceptions is that hearsay is allowed when we have an independent reason to believe that the declarant's testimony is true. When there is no such independent confirmation of the declarant's testimony, we do not allow the declarant to, in effect, testify through someone else's mouth, and thus avoid cross-examination and credibility assessment by the jury. Where there is a good reason to believe that the declarant's statement is true, a cross-examination would be moot, and a credibility determination is unnecessary. Therefore, there is no danger in allowing the hearsay to be admissible.
Can change a veteran's life. The process is simple. Fill out the form and a member of our team will call you to arrange picking up your car. Visit vehiclesforveterans.org to learn more.
Happy day, have it your way.
During a judicial hearing or trial, many different types of testimony will be offered. One area of testimony that's given special treatment is opinion testimony. The first principle of opinion testimony is that it's disfavored. The general preference is that witnesses tell the judge or jury what they know, and let the triers of fact draw conclusions that are warranted. There's therefore a general principle that testimony as to witnesses' opinions will not be allowed unless there's a good policy reason to allow it. Still, opinion testimony can be necessary, helpful, and admissible under a variety of circumstances. We will focus on 2 types of opinions. The first is that given by an ordinary or lay witness. The second is opinion testimony coming from someone who is qualified as an expert in the relevant field. Because the rules vary greatly between how these 2 types of opinions are treated, we will deal with them separately. We'll start with lay witness testimony. Opinion testimony offered by lay witnesses is limited in 3 important ways. To be admissible, lay witness opinion testimony must 1. Be rationally based on the witness's perception, 2. Be helpful to clearly understanding the witness's testimony or to determining a fact at issue, And 3, not be based on scientific, technical, or other specialized knowledge. Lay witness testimony often begins with the witness testifying to observations that he or she personally perceived. For example, say a witness states, "I observed a black truck approach a red light and continue driving through without stopping." This is testimony as to a factual observation. Next, the witness states, "The black truck appeared to be moving faster than the posted 30-mile-an-hour speed limit." This statement is an opinion, since the witness has no reliable scientific basis upon which to be sure that it's accurate. Still, the latter statement would likely be accepted by the court because it satisfies the 3 elements we discussed earlier. It's based on what the witness perceived, it's helpful to determining how the collision occurred, and it's not based on scientific, technical, or specialized knowledge. The witness was careful to provide only an approximation of speed because providing the precise speed would be beyond what anyone could reasonably determine from simply observing a moving vehicle. Moreover, an ordinary person would be expected to be able to approximate the speed of a moving vehicle. Finally, it's essential to allow this testimony because there's no other reasonable way to convey this important idea to the jury other than through opinion testimony. On the other hand, if the witness stated the car appeared to be driven by somebody who was intoxicated, this may not be allowed. While the opinion may be reasonable based on observations, it's better for the witness to simply testify as to his or her direct observations. You might, for example, state that the car was swerving or moving in and out of lanes at random. The trier of fact can then decide whether those observations warrant a conclusion that the driver was intoxicated. Now we'll move to expert witness testimony. Experts are given more latitude in expressing opinions than are lay witnesses. To qualify as an expert witness, the witness offering the testimony must meet preliminary requirements. First, prior to offering an expert opinion, a witness must be formally recognized by the court as an expert in the area of expertise that relates to the opinion. This requires that the witness testify to having knowledge, skill, experience, training, or education in the area of expertise. For example, in a car accident case, one party may wish to present a medical opinion regarding his back injuries. A witness may be qualified as an expert by demonstrating, usually through his own testimony, that he is a medical doctor currently licensed and is certified by the American Board of Physical Medicine and Rehabilitation in spinal cord injuries, and has years of experience in the field, and maybe has performed relevant procedures, or perhaps has published in medical journals. Based on this testimony, the court can accept the witness as a medical expert. Of course, if challenged, the court may require that the credentials be verified before accepting a witness as an expert. Once a witness is accepted by the court as an expert witness, the expert may offer an opinion if 1. The expert's scientific, technical, or other specialized knowledge will help the court or jury understand the evidence or determine a fact and issue. 2. The opinion is based on sufficient facts or data. 3. The opinion is the product of reliable principles and methods. And 4. The expert has reliably applied the reliable principles and methods to the facts. Not only does the witness need to have a background that qualifies him in the area, but he also must apply that knowledge in a manner that the court finds reliable. This involves focusing on the theories and techniques underlying an expert's opinion. The factors a court may consider in assessing an expert opinion include whether the underlying theory or technique has been tested and subjected to peer review, the known error rate for the theory or technique, and whether the theory or technique is generally accepted by experts in the relevant scientific community. Expert opinions are deemed reliable if they stem from principles and methods that have been tried and tested over the years. Novel theories and techniques pose more of a problem simply because there's less research and data supporting them. There are 2 important distinctions that differentiate opinions offered by lay witnesses and expert witnesses. First, expert witnesses do not need to personally perceive or observe the facts that form the bases of their opinions. Frequently, expert opinions are formed from a combination of facts that they have learned from the case, such as details of a car collision, and the data they know from their field, such as medical principles and studies. If the expert relies on facts or data that the experts in that field would reasonably rely on, then those facts and data do not need to be introduced into evidence. Thus, if the expert bases his opinion about a party's spinal injury on a medical study he reviewed in a medical journal, the article does not have to be admitted into evidence with his opinion. If the expert relied on information that is not normally admissible, then that information may only be admitted if its probative value outweighs any prejudicial effect. In other words, the inadmissible piece of information must be so valuable to the case that its value outweighs any harm the information may cause to a party. So, for example, if a medical expert seeks to testify as to an opinion that is based partially on hearsay that would not be admissible, perhaps something he heard while conducting an interview with a witness to the incident, then the other party may be able to get the hearsay admitted to support an argument that the expert misrepresented or misunderstood something the witness said. Commonly, this issue arises during cross-examination of an expert witness, where the person conducting the cross-examination asks the expert to disclose the facts or data he relied on in forming his opinion. While the expert may not be required to disclose this information in the first instance, if he's asked to provide this information on cross-examination, he must do so. Opinion, on the other hand, has no such limitation. The historical rule was that witnesses, whether lay people or experts, were not supposed to pass judgment on the ultimate issue in controversy. That was the job of the finder of fact. While a witness, for example, may testify as to how fast a car was moving, the theory went that the witness should not testify that she believes the driver of the red car was at fault in the accident, because determining who is at fault is the jury's job. The federal rules of evidence have abandoned this historical rule, as Rule 705 states that testimony is not objectionable just because it embraces an ultimate issue. Of course, opinions as to the ultimate issue in controversy must meet the other rules that are applicable to opinion testimony. Thus, an opinion to whose fault an accident is may be inadmissible simply because it's not warranted by the observations or not necessary to assist the trier of fact. However, with regard to criminal trials, the federal rules do provide that a witness must not state an opinion about whether the defendant did or did not have a mental state or condition that constitutes an element of the crime charged or of a defense. For example, in a murder trial, a witness may say John pointed the gun, informed the victim that he would shoot, and did so, but may not say John intended to kill the victim. In all cases, opinions must be supported by adequate foundations. Both lay witnesses and expert witnesses must offer testimony establishing that the witness is the appropriate party to offer an opinion, and that the opinion stems from an appropriate basis. The court when opinions are properly presented to
online
It's also sometimes referred to as the original writing or original documents rule. The foundation of the best evidence rule is that the original writing, recording, or photograph is the best way to prove the actual content of the evidence. This is because requiring best evidence ensures that litigants provide evidence that will best facilitate a court's task of accurately resolving the disputes at hand. Other evidence of a writing, recording, or photograph will be admissible only if the original document is not available. A photocopy is generally considered the same as the original, unless there is a genuine concern that the photocopy is not a real representation of the original. The original documents rule serves to exclude documents that paraphrase or restate the original. This presentation will address what the best evidence Commonality. It would be impractical to handle all of their claims in a single lawsuit. The third element is typicality. The typicality requirement doesn't focus primarily on the class members, but on whether the class representative or named plaintiff are typical of those in the class. For example, the United States Supreme Court held that the named plaintiff claim share the same essential characteristics as those of the putative class. Provided that such claims arise from a similar course of conduct and share the same legal theory, factual differences will not defeat typicality. Finally, the class representative must demonstrate that he will fairly and adequately represent the interests of the absent class members. In making this determination, courts will focus on whether the interests of the class representative and class members conflict, whether the injuries allegedly suffered by the class representative are similar to the absent class members, whether there are any issues upon which the class representative and absent class members disagree, and whether the attorneys hired to handle the class action have the capability to represent the class skillfully and competently. Once a class is certified, Rule 23b provides a class representative must demonstrate one of the following additional reasons that the action should be brought as a class action rather than by each individual plaintiff individually. 1. Litigating separate actions would risk inconsistent adjudications, and would thus establish incompatible standards of conduct for the defendant, or would, as a practical matter, resolve the interests of other class members. Or 2, the defendants have acted or refused to act in a manner that is generally applicable to the class. And 3, the common questions of law or fact predominate over an individual class member's claims, and a class action lawsuit is therefore superior to other methods of adjudication. Let's look at these in more detail. The first possibility is that litigating separate actions would risk inconsistent adjudications that impose incompatible standards of conduct. When construing Rule 23b(1), an individual should consult the advisory committee's notes, which explain as follows. One person may have rights against or be under duties towards numerous persons constituting a class, and be so positioned that conflicting or varying adjudications in lawsuits with individual members of the class might establish incompatible standards to govern his conduct. The class action device can be used effectively to obviate the actual or virtual dilemma, which would thus confront the party opposing the class. Essentially, Rule 23b(1) strives to safeguard absent class members from litigation that could negatively affect their ability to safeguard their interests. The second justification for the class action is when the defendants have acted or refused to act in a manner generally applicable to the class. Under this rule, Rule 23b(2), the class representative must demonstrate that A, the defendant acted in a manner that is generally applicable to the class, B, the class members have standing to seek the type of relief requested, and C, a single remedy, such as declaratory or injunctive relief, would benefit each member of the class. Put differently, the class representative may not seek individualized legal remedies for each member, and this includes a prohibition on class members seeking individualized monetary damages or amounts. The third possible justification is that common questions of law or fact predominate over the individual class members' claims. This is true under Rule 23b(3) of the Federal Rules, and where common questions of law or fact predominate over individual claims, a class action lawsuit is a superior method to fairly and effectively resolve the legal issues. Once the class action is certified and moving forward, members of the class must be notified of the existence of the class action and explained their rights. This is typically done by mailed document that announces the pending class action and explains the rights of members of the class to them. Each member of the class has the following option. 1. The member can do nothing and remain part of the class. 2. The member can opt out and choose not to go forward as part of the class. Or 3. The member can retain her own attorney to represent her in the class action proceeding. If the class member does nothing and remains part of the class, then he or she will share any judgment or settlement that the class action lawsuit eventually earns. However, that class member is not able to bring a separate lawsuit based on the same facts. In other words, the class member is bound by whatever result the class action brings. If the class member opts out, she does not share in any judgment or settlement and will receive no benefit from the class action lawsuit, but may bring a separate cause of action based on these facts. The class member would do this when he feels that he has a strong case and will likely win more by bringing his own lawsuit than he would by sharing in the benefits of the class action judgment or settlement. The third option allows the class member to retain her status as a class member but have her own attorney represent her interests to ensure that the class action proceeds in a manner that is fair and advantageous to the class.
Your business made limitless. That's Life Unlimited.
Sun drops. Just drop, mix with my lotion, and glow. The feel-good feeling of Jergens.
In our previous presentation, we looked at federal question jurisdiction under 28 United States Code, Section 1331. Next, we turn to federal subject matter jurisdiction under Section 1332, based on diversity of citizenship. Diversity jurisdiction applies when the plaintiff and defendant are from different states and the amount in controversy is more than $75,000. If there are multiple plaintiffs and multiple defendants, no plaintiff can be from the same state as any defendant. So, for example, if plaintiffs from Texas, Georgia, and Illinois jointly sue 3 defendants from Missouri, Maine, and New Jersey, there is diversity jurisdiction. However, if plaintiffs from Texas, Georgia, and Illinois jointly sue 3 defendants from Missouri, 1 from Georgia, and 2 from New Jersey, there's no diversity jurisdiction, because a plaintiff and defendant each hail from Georgia. The rationale behind diversity of citizenship jurisdiction was discussed by the Supreme Court in the case Guarantee Trust Company v. York, where the court reasoned that diversity jurisdiction is founded on assurance to non-resident litigants of courts free from susceptibility to potential local violence. Jurisdiction is based on the citizenship of the parties. While citizenship of a country is a well-defined term, citizenship of a state is more complex and is seldom relevant for any other purpose. But can only have one domicile. In Williamson versus Unseton, the Supreme Court clarified this rule. There, the ex-wife of a West Virginia moved to Virginia, where she then brought an action against her ex-husband. Virginia was solely for purposes of the divorce. The Supreme Court held that since domicile is determined at the time the complaint is filed, the wife had the domicile, as she was in Virginia and intended to stay there. She had been there only for a short period of time is irrelevant. As corporations can also be parties to federal actions, it is also often necessary to determine the citizenship of a corporation. The rule there is that a corporation is a citizen of each state in which it is incorporated, and the one state in which it has its principal place of business. As a result, a corporation can be a citizen of many states, as a business may incorporate in as many states as it chooses. Different courts have adopted different approaches to define principal place of business, until 2010, when the Supreme Court endorsed the nerve center approach to principal place of business determination in the case of Hertz Corporation versus Friend. Under this approach, the principal place of business is the nerve center of the business, which means the state where the corporate headquarters are located and from which the corporation's highest officers control, coordinate, and direct its activities. The amount in controversy in diversity cases must exceed $75,000, exclusive of interests and costs. The amount in controversy means the minimum judgment that could be supported by competent proof. Competent proof means evidence supported by estimates or reasonable accounting methods, which need not necessarily be formal.
If multiple claims are brought by one plaintiff against one defendant, the total dollar amount of all claims can be aggregated to reach the $75,000 threshold. However, if one person brings claims against multiple defendants, and each one is based on a different cause of action, these cannot be aggregated to satisfy the threshold. It is important to note that most diversity of citizenship cases and many federal question cases are instances of concurrent jurisdiction. This means that these cases can be brought in federal court or in state court. However, if the case is eligible to be brought into federal court and is brought in state court instead, the other party may remove the case to federal court. In other words, if there is federal subject matter jurisdiction, either party may decide that the case must be heard in federal court. It stays in state court only if both parties agree to leave it there. There are, however, certain types of cases that can only be brought in federal court. These are cases in which the federal courts have exclusive jurisdiction. Examples of cases in which federal courts have exclusive jurisdiction include bankruptcy filings, seizures of property under federal law, and federal criminal prosecutions. While federal courts are courts of limited jurisdiction, they have original and sometimes exclusive jurisdiction where the case is based on federal law, and concurrent jurisdiction with the states where there is diversity of citizenship and the amount in controversy is more than $75,000.
Attention shoppers, want to spend less? Go to Aldi. They're #1 in everyday low prices.
Change a veteran's life. The process is simple. Fill out the form and a member of our team will call you to arrange picking up your car. Visit vehiclesforveterans.org to learn more.
Federal courts are courts of limited jurisdiction. This means that federal judicial power extends only to specific and limited types of cases. This presentation will discuss federal courts' subject matter jurisdiction. Before a court can get to the merits of a case, it must have the authority to decide the issue at hand. The authority of the court to render a decision on a type of case is called jurisdiction over the subject matter. While courts also require authority to determine the rights and liabilities of the parties before it, a concept known as personal jurisdiction, this discussion is limited to the types of cases federal courts may hear. The rules governing subject matter jurisdiction in federal courts are derived from two sources. First is Article 3, Section 2 of the United States Constitution. Article 3 lists the types of cases that federal courts may hear. The categories allowed to federal courts under this provision are broad and encompassing. However, authority to hear a case under the Constitution is insufficient to allow federal courts subject matter jurisdiction. Rather, since Congress sets up and establishes the rules for federal courts, there must also be statutory grounds for jurisdiction. The United States Code in Title 28, starting at Section 1331, sets forth the types of cases that may be heard in federal court. The two most important federal statutes that grant jurisdiction to federal courts appear in Section 1331 and 1332. Section 1331 granted jurisdiction is sometimes known as federal question jurisdiction, while 1332 establishes federal jurisdiction based on diversity of citizenship. This presentation will focus on federal question jurisdiction. Under Section 1331, federal courts have jurisdiction over civil actions that arise under the Constitution, laws, or treaties of the United States. Most cases brought in federal court rely on Section 1331 for jurisdiction. The most obvious case in which Section 1331 applies is when federal law creates the cause of action. For example, a lawsuit brought by one company against another under a cause of action created by the Sherman Antitrust Act could clearly be brought in federal court because the claim arises under federal law. Things become a bit murkier when the cause of action is not necessarily federal. It may, for example, be an ordinary cause of action which is based on state law, but where there is some federal law involved in the case. For example, what if a victim of food poisoning sues a canned food manufacturer under a standard product liability theory?
a state law cause of action, but uses federal food safety regulations promulgated by the Food and Drug Administration to show negligence by the manufacturer. Is there federal subject matter jurisdiction because the complaint involves federal law, or is there no federal jurisdiction because the complaint is fundamentally based on a state law cause of action? To answer this question, the Supreme Court developed the well-pleaded complaint rule. The rule dictates that if the well-pleaded complaint, which means a complaint that properly alleges a cause of action, depends on a question of federal law, then the federal courts have jurisdiction, even if the underlying cause of action is based on state law. For example, in Louisville Railroad Company versus Motley, a couple had been injured in a train accident. As compensation for their injuries, the railroad agreed to provide them with free railroad passes for the rest of their lives. 20 years later, a new federal law made the giving of certain types of free passes illegal, and the railroad company refused to honor the agreement with the Motleys because it believed that it violated federal law. The couple sued to enforce the original agreement in federal court, arguing that the agreement did not violate the new law. The Motleys alleged that there was federal question jurisdiction, because even though their claim was a breach of contract claim, which is based on state law, the issue in controversy was clearly going to be the application of this new federal law, and whether it prohibited the continuation of the free passes. The Supreme Court, though, held that there was no federal question jurisdiction, although there was bound to be a discussion of the federal law, and while the case would ultimately turn on the interpretation of the federal law, the cause of action itself had nothing to do with federal law. The cause of action was based on breach of contract. The allegation was simply that the railroad failed to follow through with its agreement to allow the plaintiffs free railroad passes for life. Thus, the complaint did not depend on issues of federal law, and so there was no federal subject matter jurisdiction. Anticipating the opponent's defense will be based on federal law is insufficient. The plaintiffs must show that the original cause of action arises under, or at least depends on, federal law. The Supreme Court clarified and fine-tuned the well-pleaded complaint rule in a series of cases over the century after Motley was decided. In 1983, the court explained that federal question jurisdiction applied where the basis of the lawsuit necessarily turned on a construction of federal law. A few years later, in Merrill Dow Pharmaceuticals Incorporated versus Thompson, the court again weighed in on this question to add the requirement that to establish federal question jurisdiction, a state cause of action must not only depend on federal law, but must depend on a substantial question of federal law. That case was a product liability action that, in part, alleged misbranding of the drug Bendectin under the Federal Food, Drug, and Cosmetic Act. While conceding that the cause of action depended on interpretation of the Food, Drug, and Cosmetic Act, the court nevertheless denied federal question jurisdiction because the violations alleged here were not substantial enough, and the record indicated that Congress didn't intend violations of the Act to lead to federal causes of action. The Merrill Dow test defined the issue as interpretation of congressional intent. If the question was important enough that Congress likely would have approved the issue being decided in federal court, that's sufficient. 20 years later, the Supreme Court applied this in Grable & Sons Metal Product Incorporated versus Daru Engineering and Manufacturing. There, the IRS had seized Grable's property to satisfy a federal tax debt. Grable brought an action in state court to quiet title, which means to get a judgment that the property was his, arguing that the IRS had not satisfied certain notice requirements before seizing the property. Here, the court held that the state cause of action did depend on a substantial question of federal law, because the federal government had a strong interest in collecting delinquent taxes. While applying the well-pleaded complaint rule for federal subject matter jurisdiction is obviously a complex process, the rules seem clear that where federal law creates a cause of action, federal courts automatically have subject matter jurisdiction to hear the case. Where the case is brought under state law, there is federal question jurisdiction where an important federal law is at issue and where the complaint requires application of that federal law to go forward. In our continuation presentation, we will discuss other aspects of federal subject matter jurisdiction, including that based on diversity of citizenship.
Welcome. We're back. This is our second video. Now we're going to talk about subject matter jurisdiction. I'm going to give this one more time since this was early in the semester. Keep in mind that we'll be talking about a bunch of stuff today, but our time is limited. Just because I don't say something doesn't mean it won't be covered on the exam. And just because I say something doesn't mean that it will. With that in mind, let's turn first to Article 3 versus 1332 diversity. First, the scope of Article 3 is broader than the diversity statute 1332. Here's Article 3, Section 2, provides constitutional power for and citizens of a state, respectively what we now call diversity jurisdiction and alienage jurisdiction. Keep in mind that there's two ways the Constitution is significantly broader than the diversity statute 1332A. First is there's no amount of controversy in Article 3. Amount of controversy is a statutory requirement. Second, the Constitution would permit minimal diversity. So, for example, if you had Pennsylvania versus Florida and Pennsylvania, that would be fine because there's minimal diversity between the plaintiffs and defendants. The complete diversity rule, which requires all plaintiffs to be completely diverse from any opposing defendants, that's a creation of the courts when analyzing and interpreting the statute. So complete diversity is not required by the Constitution, but rather by Section 1332. Well, let's turn to 1332. We'll start digging our teeth into it. Now, first, we're going to talk about what does it mean to be a citizen of a state. It requires, first, a lawsuit between citizens of different states, and second, an amount of controversy that exceeds $75,000, not counting interest or costs. Right now, let's talk about what does it mean to be a citizen of a state. That means to be, first, a U.S. citizen, the second, who's domiciled in a state. If either one of these is missing, then that person is not a citizen of a state. So if somebody is a foreigner who's domiciled in a state, they are not a citizen of a state. They're a foreigner. Even if it's a foreigner who's domiciled in the state, who's a lawful permanent resident, that person is still a foreigner. They are not a U.S. citizen. Let's expand upon this. U.S. citizen domiciled in the state is an incomplete analysis, right? To be domiciled in the state, you have to reside in the state and have the intent that's either to stay for the time at least, to stay indefinitely, or to stay permanently. Courts vary on their approaches. That should tell you something very important. If you have an essay and you must analyze domicile, look very carefully in the call to question or the instructions to see, do the instructions tell you to use the majority approach, or are the instructions silent on which approach to use? If the instructions tell you to use the majority approach, then use the indefinite intent approach, the one from the Gordon case that we studied in the very first week of school. If the instructions are silent, then you may have to analyze the alternative. All right. U.S. citizen, domicile. Domicile means reside in the state, to represent intent, and then at the time the cause of action arose, the time the complaint is filed, or the time of trial. Time you file, that's right. What matters is the time of filing. This slide, of course, just fleshes out what I just said. Domicile is reside in the state, intent. That second requirement has three approaches. And another way of looking at it is like this. Now, you'll remember we did this in the very first week or two of class. This is a model on how to structure the issue of citizen of a state, right? You'd have to address all these things just to determine whether a particular individual is a citizen of a particular state. And again, just to remind you, what if you have Nathanson, born in the U.S., citizen of the United States, and he moves to France? Is he a citizen of a state? No. He is stateless. He cannot sue, nor can he be sued under diversity. If he wants to be in federal court, it's got to be a federal question. Okay? Let's see. Let's look at the statute for a minute. Let's talk about this, the alienage statute. Alienage statute, 1332A2, he's check. Is he a citizen of a state? No. What if he moves to Pittsburgh, PA? Does he become a citizen of a state now? No, he's still check. What if he becomes a lawful permanent resident who lives in Pittsburgh, Pennsylvania?
When you type a response in...
He is not. So let's be
When-
very clear about how
when you type a response in...
jurisdiction under section A2.
When you type a response...
This is the threshold thing that
When you type a response in live transcribe, your message will be...
then there's no alienage jurisdiction under A2, which requires first a citizen of a state. It can be plaintiff or defendant, doesn't matter.
When you type a response
The analysis we covered in the handout, a visual from a few moments ago. Then the other person needs to be an alien. Okay? We don't care where they live. We care that they're not a U.S. citizen. All right? If you have that, then the first condition is met. Then what about the language after the comma? Well, the language before the comma is a grant of alienage jurisdiction, and everything after the comma divests alienage jurisdiction. And it tells us that even when the first clause is met, we will divest that grant of jurisdiction if the alien is a lawful permanent resident who lives in the same state, who's domiciled in the same state as an opposing party. Domiciled in Florida versus defendant who's from France, so alien, who's a lawful permanent resident who's domiciled in Florida. Well, under the first clause, what you have is a citizen of the state, and you have
Now, before I begin, I'd like to introduce myself. My name is Eric Nakano, and I'm the staff attorney at the Self-Help Center at the downtown courthouse. This is run by a legal nonprofit called Voluntary Legal Services Program, and we've been in operation for roughly a year and a half. During that year and a half, we've assisted thousands of people. Actually, about 7,000 customers have come through. And this presentation is built on part of the experience that we have had handling and assisting self-represented litigants make their way through the court system. Now, before we go into anything, I'd like to begin on just a little bit of a personal story. I absolutely despise legal dramas on television. I watch these programs, and one of the things that I find myself doing is objecting during the courtroom scenes. Every time an issue of law comes up, I find myself going at the TV, that's not right. Now, I suspect that I love medical dramas, and I suspect doctors do the exact same thing during medical dramas. But I think ultimately the difference between the two is that when you finish watching a medical drama, there are very few people, if any, that have ever walked away from an episode thinking that, you know, I should go out and perform an appendectomy. Nonetheless, one of the most frequent things I hear from people when talking about the law is that, but it wasn't like that on television. So the fact that you're here today, I'm hoping will get you on the right foot as far as beginning a civil case in court. And with that, I will start by just letting you know that almost everything you have learned on TV about the law is wrong. I've even got a handout to that effect inside your packet. Whoops. My first mistake of the day. Now, before we begin, I'd like to go over a little bit about what the scope of this class is today. This is designed to be a basic introduction to starting a simple civil lawsuit. It's not designed to go into depth on any particular subject, just to how to handle some of the simplest cases in their earliest stages. If you are trying to file a complex 42 U.S.C. 1983 civil rights claim, we're probably not going to have much that's all that useful for you. Or if you have very specific questions about a particular area of law, we're not going to be covering it today. This is just an overview designed to let you know how to start a case and where you might find some additional information. Now, some things we're specifically not covering are filing lawsuits in the federal courts. We are only handling the Superior Court today, and specifically, we're focusing on Sacramento County's rules. We are not covering small claims court. The process there is different, and the forms are different, but they're fortunately a lot easier to navigate. We're not dealing with family law or probate. Once again, these have different forms in a completely different system. And finally, criminal and traffic court, we're not even touching it. So the first question I want you to ask yourself is, why are you filing a lawsuit? Now, the basic answer to this is because somebody has done something wrong and it has harmed you. Now, there are a few different theories that you can raise a lawsuit under. The first type of wrong would be under contract. If you have a contract with someone and they break that contract, or they do something else that's prohibited under that contract specifically spells out what each person is supposed to do, and in some cases even spells out what the penalty for not doing it is. These are some of the easiest cases to handle because you know going in exactly what each person needs to do. Well, the other theory you might bring a lawsuit under is tort. Now, all right, one moment, thank you. There we go. I think I just stepped too far away from the base, so I'll be reaching over here, doing my Vanna White to the slides. All right, tort. Well, contract spells out the rights between individuals who have entered a contract. Tort is a fundamental wrongdoing based on the idea that every person in society has a certain set of obligations to every other person in society not to do certain things. Some of these are going to be pretty self-evident. If you're walking down the street, you pretty much have a duty not to walk up to somebody and punch them in the face. They call that tort battery. A lot of these will be simple. Some have a few, are a little bit counterintuitive and have a few more elements that you're going to need to research, but the fundamental concept is a tort is a wrong based on a duty each person owes to everyone else in society. And finally, there are statutory claims. There are some laws that allow, as a remedy for someone breaking that law, a person to file a civil lawsuit for either damages or some other form of enforcement. One of these might be, for example, violation of the Fair Debt Collection Practices Act, which allows a person who's been wronged under that act to file a lawsuit and seek damages, and they even set the amount of damages within the statute. Let's see if we turn now. Next question I want you to ask yourself is, do I really want to bring a case in the Superior Court? Because lawsuits are a long, slow, drawn-out process, and you may have some alternatives to actually bringing a lawsuit. One of these is, of course, you can negotiate and settle with anybody at any time. If you have been wronged, one of the first things you might want to do with somebody is to talk to the person and ask them to write it. Write them a letter. Demand that they fix it. This is usually your first step, because if you can settle it at that point, you've saved yourself all the time, energy, and expense of going to court. You and the other person might agree on mediation. Mediation is where a dispute is brought to a neutral third party, and the people come together and they discuss the issues from each of their sides and ultimately, hopefully, come up with some sort of compromise between the two that each of them can live with. The advantage of a mediation is that, while a lawsuit is generally a winner-take-all type of situation, a mediation will create something in between that everybody can live with. The sign of a good settlement is oftentimes, or a good negotiated settlement is oftentimes, that each side hates it just a little bit. Arbitration. Arbitration is where a case goes to a neutral third party who hears the case and makes a decision much like the court might do it. The difference is it's a less formal process, and it's usually a lot faster, and it's done outside of the court in many cases. Finally, if you're an individual and you're suing, and you can sue in small claims court for cases up to $7,500. You get one case at that amount and a number of different cases at a lower amount. But you might consider small claims court. The advantage of it is it's much, much faster. You'll get a hearing date within a couple of months and a judgment after that. It's actually, if you've ever seen the People's Court or Judge Judy, small claims court works a lot like that, but with less sass and usually much less entertainment value. But it is very fast. The disadvantage, of course, is that your appeal rights as a plaintiff are limited if you lose, and it's really not suitable for handling more complicated disputes, because you'll usually have maybe 15 minutes to present a case. Now, the next question before you begin any sort of lawsuit is you need to know who you're going to sue. And I know it's silly, but a lot of people that I've seen don't have a clear idea who they're suing. First question is, who is responsible for the harm that you've suffered? if you are to win a lawsuit, you must allege that somebody has done something wrong and prove it. And typically you sue the person who has done the harm. Now, one of the tricks that I wanted to share with you that I see all the time is when people are involved in automobile accidents, their first instinct is to turn around and sue the insurance company for the driver of the other car. While it's true that the insurance company ultimately pays the claim if it's won, their duty is a contractual duty with the driver of the car to pay if they lose and to defend them in court if they're sued. They're not the actual ones that did anything wrong. You are always suing instead the driver and or the owner of the other vehicle. Let's say the other side is a corporation. Corporations, LLCs, partnerships, these can all be sued as an entity. They are essentially legally people and can be sued in their own name. Additionally, partnerships, you can sue each of the partners in a partnership, at least the ones that have done something wrong, if nothing else. Finally, if you're dealing with a business that's a sole proprietorship, the owner is essentially the business. The owner is the person being sued, usually doing business as whatever the business name is. One last thing, if you're suing somebody who has died, you can bring claims against the estate, but this is only going to be worthwhile if there's actually any money in the estate. So if somebody has died and there's nothing there, you're probably just wasting your time and energy bringing a lawsuit. All lawsuits must be filed within a limited amount of time after the wrong has been done. This is called the statute of limitations. Now, the rebuttal I usually get from people is, but murder doesn't have a statute of limitations. The answer to that is, of course, murder is a criminal offense. In civil law, everything has a statute of limitations. Sometimes it's long, sometimes it's extremely short. The clock to file usually starts whenever the wrongdoing takes place. It can sometimes be told to a later date, for example, where an injury is not discovered until later. But the first date you want to concern yourself with is when did the damage take place? And the next date you want to also be aware of is when did you realize it took place and when would a reasonable person know it took place? The clock stops on the day the lawsuit is filed. The time between those two must be less than the statute of limitations. So what are some common statute of limitations? If you're suing on an oral contract, it's typically 2 years from the breach of the contract. An important exception to this is going to be if the contract doesn't have a specific date of performance, in which case it's going to run from the date that the contract was entered. So if you and your friend decide that your friend is going to pay you back the money you loaned, but you just say, I'm just going to come back and demand it later and you're going to pay me, your statute runs from the date you made the agreement. On the other hand, if you say payments will begin on a specific date and then that person doesn't pay, they start running when they've missed the payment. Problem with oral contracts is they're usually very, very hard to prove. So if you walk away with something else today, make your contracts in writing. It's much easier to, as a lawsuit. Plus, it gives you a 4-year statute of limitations, which is a nice bonus. Personal injury claims generally need to be brought within 2 years from the date of injury or the date of discovery of injury or when the injury would have reasonably been discovered. So if you're in that car accident and you're injured, 2 years from the date of that accident. Property damage. This is actually an error on the slideshow. If you're going along with this, please mark out 4 years, 3 years. I should have caught that one before. 3 years from the date of the damage to your property. Fraud, 3 years. And there are statutes of limitations for all sorts of other things. Sometimes this is one of the more difficult issues you're going to be researching in your case, is what is the applicable statute of limitations. One final thing that I wanted to warn you about. If you are filing a tort case against a governmental entity, you are generally required to file a claim within 6 months of the injury taking place or the damage taking place. If it's with a local entity, it's filed with the appropriate agency for the local entity. If it's a state entity, it's filed with the state's Victims' Compensation Board. The purpose of doing this is that governmental entities are immune from lawsuits. However, under the Governmental Torts Claims Act, if a person timely files a claim, the government will waive that immunity for certain types of claims and will give what is called a right to sue letter if they decide not to process and pay the claim. If you fail to go through this first step and you file a tort claim against a governmental entity, the first thing you're going to get back is something called a demur, which is a challenge to the case itself procedurally, stating that you didn't file your claim. Now, another area where you're going to need to file a claim is in employment law actions. Typically, wrongful termination or discrimination cases require you to file a complaint through the Department of Fair Employment and Housing, which is then usually concurrently filed through the Federal Equal Employment Opportunity Commission. Once again, they will process the claim and issue a right to sue letter if they decide not to grant your request. If you're really determined to go to court, you can also request that they stop their investigation and issue a right to sue letter sooner. And there are some strategic instances where that might be advantageous. Hopefully, if you are in one of those situations, you have an attorney who handles employment law because it will make your life a lot easier. Now, we talked about contracts, spelling out the rights that everyone has within a lawsuit. Some contracts require you to arbitrate your claim. One of the possible things if you are required to arbitrate your claim under a contract is if you file your lawsuit within the court, the other side might file a motion to dump it back into arbitration. So if you're required under the contract to arbitrate your claim, it's oftentimes easier to simply start the case through the arbitration proceedings. Likewise, some contracts allow either side to demand arbitration, in which case you're going to want to determine whether you want to handle this in court or whether you want to handle it in arbitration, and be aware that the other side, as their first response to their lawsuit, might be to demand arbitration and get it kicked over into arbitration. As a final note, before you even choose to sue, you want to consider the finances of your lawsuit. How much money is involved in this case? If you're talking about suing over a few $100s or even a few $1,000s, if you can take the case to small claims court, you might seriously consider doing that. These cases that are under a certain amount, they're not worth hiring an attorney as a general rule. They're also, assuming that your time has some value, possibly not even worth your time pursuing through the Superior Court, given the amount of time and energy it's going to take. But small claims court is a completely different matter. Win or lose, you'll have a decision and you won't have spent that much time on it. Next, is the person you're looking at suing worth anything? If you are suing somebody who's well insured or has assets or money, or who has the potential to have assets or money, well, then that's a good indication that it might be worth bringing the lawsuit, because at some point, even if they don't have it now, and if you win, you might be able to get it later. On the other hand, if you're suing somebody who is not insured, maybe who has nothing, maybe who's homeless, any of these things where they don't have it now and are unlikely to ever have anything you can collect in the future, you might want to consider whether or not it's worth bringing the lawsuit. It might be, because you never know. Even the most destitute person might win the lottery. On the other hand, are you interested in spending the amount of money it will take to file and bring your case for the chance that someone else might win the lottery? And finally, what will it cost you to prove your case? Different cases have different types of proof that's necessary. Contract claims are usually pretty straightforward. What do you need to prove a contract? Well, you need to show that the contract exists. You need to show what the conditions and terms of the contract were. You need to show that the person broke the contract, and you need to show the damages that were incurred as a result. Well, between yourself, the other party, and maybe a couple of witnesses, you probably, and other documents, you might have exactly what you need to prove that case. They're not that expensive to prove, relatively speaking. On the other hand, if you're bringing a medical malpractice case, the judges are not doctors, the lawyers are not doctors. None of us know whether or not somebody is acting within the reasonable standard of care for a doctor in the profession. The only people who can testify as to this are expert witness doctors. This means that to bring and prove your medical malpractice case, you are likely going to be spending between $60,000 and $100,000 to bring that case. Now, if the likelihood of your damages, multiplied by the amount of, the percentage that you're likely to recover, don't add up to what it's going to potentially return, the case is probably not a good investment. This is why I always suggest people who handle medical malpractice cases or who have medical malpractice cases to always seek representation, because if you have a truly good case, there is an attorney that will be interested in handling it on a contingency fee, although there are a lot fewer now that we've passed tort reform in California, which limits damages for pain and suffering. So they tend to handle only the best cases. Otherwise, you will want to determine whether or not you can financially survive the case. Now, before we start going into the paperwork, the last couple of considerations you're going to want to consider are, can you file the suit in California, and where are you going to file it in California? The first question is called jurisdiction. There are certain activities, actions, or agreements that give California the ability to hear a case. Typically, California can hear a case if one or more of the defendants resides in or does business in California, or if the damage or injury took place within California, or if an out-of-state business has significant contact with California. There are other, specific details, but the first thing is, well, how is this case tied to California? And if it's not tied to California, you're looking at, other than the fact that you're here, because it's going to be from the defendant's side, then you're probably in the wrong court. And we can talk about this a little more during question and answer. The next question is, which court in California do you file in? This is called venue. And once again, you're looking at, does one or more of the defendants live in the county in which you are filing? Did the injury take place within that county? Or was the contract entered into in that county, or was it to be performed in that county? If it's a corporation, does it have a principal place of business in that county? Or if they're individual owners of the business, is the business there, or do the owners reside there? In any event, you have to have some tie to the county in which you are filing. One of the common mistakes I see is you'll have a plaintiff in one county, a defendant in the other county, and the plaintiff will decide to try to do everyone a favor by choosing a court somewhere in the middle. Unfortunately, if nothing happened in that county, there's no reason for that county to hear it. He needs to go all the way to where that defendant is. All right. So here's the big question you're probably wondering. What forms do I need? Next time I'll slide closer. What forms do I need? To initiate a lawsuit in the Superior Court, you have to have a few mandatory forms. The first is going to be the civil case cover sheet. We'll see an example of that later. It's a form that's used for statistical purposes that lets the court know what kind of case it is. That's about it. It's relatively easy to fill out. The summons. This document's going to let the other side know you're suing them, that they have 30 days to file an answer within, after the time that they've been served with the papers, and also the name, address of the court, as well as the court number. And then finally, the complaint. And this is where we're actually going to have to go in some detail because there are a lot of different options for what can make up a complaint. First of all, you have the ability to draft a complaint on your own, or there are going to be a bunch of standardized forms. We're going to focus on the standardized forms today. Finally, every lawsuit has a fee to file it. If you are unable to pay the fee, you may qualify for a fee waiver. If you're on certain types of public assistance or have an income for your household below a certain amount, which is currently defined at approximately 125% of the federal poverty guideline, then the court will waive your filing fee. You might also have other circumstances, such as extraordinary medical bills or other expenses that might allow the court to grant the waiver of this fee. If in your case you are asking under $10,000, your filing fee is going to be $180. Over $10,000 but under $25,000, your filing fee is $300. And over $25,000, it's $320. The forms you would use to ask for a fee waiver are the application for waiver of court fees and costs and the order on application for waiver of court fees and costs. Both of these forms are available online, and also you can get them from the court simply by asking for a fee waiver packet. Finally, if you're suing on a personal injury claim, you're going to want to prepare a statement of damages. Personal injury claims don't allow the amount of damages to be specified inside the complaint. The problem you have is if the other side ends up defaulting, you're limited to the amount of damages that you've notified them about. So the statement of damages form lets them know how much you're asking for in your case, and you typically will be serving it with the complaint. And finally, if your case is under $25,000, you might consider doing a case questionnaire, which is a form that you fill out that has a number of the common question sides in a small lawsuit might ask each other, and would then obligate the other side to answer the exact same questions. They do this in small cases as an option to simplify the amount of paperwork that needs to be exchanged back and forth. So the complaint. The purpose of the complaint is to let the other side know what you're suing them for and what specifically they did wrong. That's about it. You are not proving your case with the complaint. The complaint is not considered evidence. In fact, the court, unless they go to a default or unless it's raised at trial or arbitration that you didn't raise an issue in your complaint, will never go back and even look at your complaint. So a complaint has to do a few things. It has to identify the parties in the case and what their capacity is. Who are you suing? Are they individuals? Are they corporations? Are they business entities unknown? Whatever. They need to have at least one cause of action. Cause of action is legalese for a theory that the person suing for says they're entitled to get something under. It's about as simple as I can put it. If you don't have a reason you should get something, you don't have a lawsuit. Each of these causes of action, because only certain things are recoverable under the law, has to spell out specific allegations that form each element that must be eventually proven to win. So, for example, if you're suing under a contract, you have to allege that there was a contract, when it was entered, was it oral or written, who was a party to the contract, what did the contract say, when was the contract broken, who broke it, how did they break it, and what damages were incurred as a result. Now, some of the standardized forms will really help you out, because if you fill them out properly, you'll have all of your elements. But if you start dealing with more complex issues, you're going to need to make sure that your hand-drafted pleadings list and deal with every element in a particular cause of action. And finally, your lawsuit must specify the relief you are requesting. If you want money, your lawsuit has to demand money. If you want some sort of an injunctive order, you know, that somebody be ordered to do or not do something, well, your lawsuit needs to say that. The court can only give you something if you have asked for it. So if you fail to ask for something in your lawsuit, well, the court can't give it to you. Now, I had talked about standardized forms. Most of the forms that I've referred to already have a standardized form for them. So where can you get them? You can get them directly from the court or from the Judicial Council at www.saccourt.com. There's going to be a link on the screen that says Forms, or from www.courtinfo.ca.gov/forms. And that'll take you directly to the Judicial Council's form webpage, and it will have a drop-down menu for the different categories of forms, which will kind of help you interpret when we get to the forms. So, let's talk about the first type of case we mentioned, breach of contract lawsuit. When you get to your complaint, you have two options. You can either do it on pleading paper, which is that 28-line paper with the 28 numbers on the side and the 2 lines on the left-hand side and the 1 line on the right-hand side that you can make inside of any modern word processor. A lot of attorneys do this because many of them will have templates already stored on their computer or in software that allows them to make these really quickly. Now, for the rest of us, most complaints dealing with contract can be done on standardized Judicial Council forms, and that's what I'm going to be showing you today. And there's a form called a complaint contract, which is in the pleading group. And then to that form, you're attaching your causes of action. And they have forms for breach of contract, common counts, which I'll talk to when I make a little analogy to Little House on the Prairie, fraud, and you can also attach additional causes of action, whether they're from other Judicial Council forms or attached on pleading paper. It's using the standardized forms is one of the simplest ways to make sure that you actually get everything that you need in your complaint. So I'm going to switch over and we're going to go through a sample form packet. Now, if you go ahead and find in your information packet sample pleading 1, breach of contract. Now, the first paper we talked about is the civil case cover sheet. This lets the court know what type of case you're going to be doing. Well, top of the form is something called the caption. You're going to get, by the end of the lawsuit, very good at filling out this caption. You'll notice the box says attorney or party without attorney. Most people never get past the word attorney and wonder what goes in that box. Unless you're representing someone else and you're an attorney, and I think I've got at least one in this room, you're going to be filling out your name and address. If you're represented by an attorney, it is your attorney's name and address. Where it says attorney for, if you're representing yourself, it's going to be in pro per. The box below is the street address of the court, and the case name is going to be usually the last name of the plaintiff versus the last name of the defendant, or the name of the business entity. This is called the short case name. It's a shorthand for what this case should be called. Where it says under civil case cover sheet, you're going to identify whether this case is an unlimited case asking over $25,000 or a limited case demanding under $25,000. This lets the court know what set of rules apply. If this is your first lawsuit, you're really not going to probably notice the difference, but there are a few subtle differences, especially during the discovery process between cases over $25,000 and under $25,000. You're not going to have a case number, judge, or department because you don't get any of this until you file. Actually, this court will only give you your case number. The big box underneath has a bunch of check marks as far as what type of case this is. Now, the biggest mistake on this form people will make is they check more than one box. Because the court is using this for statistical purposes, the way that they're tracking it, they only have the ability to track one of these boxes. So you're going to choose the one your case is most like. In this case, in the sample, we've done a breach of contract or warranty. Now, Kate, if we could go to the bottom of this form. Item 2. This case is or is not complex. If your case is a complex case, meaning it has many parties that are represented by counsel, thousands of pages of documents, things like that, you probably should be represented by an attorney. So I'm going to operate under the assumption you are not filing a complex litigation. And item 2, this case is not complex. If it were complex, you would check is, and you would explain why by checking the appropriate box. Next, remedies sought. Well, what are you asking for? Money, non-monetary, injunction or other relief, or punitive damages. You can check as many of those as apply. For the most part, on contracts, you're going to be seeking money. You might be seeking injunctive relief. You are almost never seeking punitive damages because for breaches of contract, breaking a contract doesn't necessarily make a person a bad person who needs to be punished. Number of causes of action. You're probably going to fill that out after you fill out the rest of your complaint. But I told you every lawsuit has to have at least one cause of action. Well, you're going to put whatever number applies there. And then finally, the case is not a class action lawsuit. Unless you are an attorney, you will never check the box is a class action lawsuit. Because a class action lawsuit requires you to represent other parties within the class. And the only person who can do that is an attorney. So there is never any time that a self-represented litigant will ever be filing a class action lawsuit. And then finally, you would date, print your name, and sign. The next form, if we go to the top, is called a summons. Purpose of the summons, once again, let them know they're being sued, tell them who's suing them, that they have 30 days to file a response with the court, name and address of the court, and who they should be sending their response to. Top box is your defendant. Now, one thing I wanted to point out is the language underneath the Doug defendant's name, and DOs 1 through 10. Most common question I get asked when people see one of these forms is, what does DOs 1 to 10 mean? Does that mean jails involved? It's actually DOs. You've heard of John Doe and Jane Doe when you have an unknown person. Lawsuits can have unknown defendants. Now, why would you put any of them in your case? This case has 10 of them. Well, you may know who the other side is, but you have those extra defendants in there in case you've screwed up and you need to add somebody in. Because if you don't have them in, it's a rather complicated mess to amend your complaint and get it in later on. If you've got those unknown defendants in at the very beginning, if it turns out that you need to bring somebody else into the lawsuit, you just file a simple paper that says that the person formerly known as Doe number 1 is now John Smith, and then have John Smith served with the papers. If you go to the bottom, you'll see that it has the court name and address written in, as well as the plaintiff's name and address. If it were an attorney, it would be the attorney for the plaintiff. The very familiar caption at the top, which will have your name and address. You're the attorney for in pro per, court's information, the plaintiff and the defendant, and there are your DOE defendants again. Exactly between the summons and the complaint. There are many, many people who have had just even a letter off when the other side fails to file an answer and they take it down to the court asking that judgment be entered, only to find that it can't be because the two don't match. Be sure to spend some extra time proofing your papers to make sure that where it says plaintiff and defendant, including the DOE defendants, that it matches the summons exactly. The designation plaintiff and defendant will remain constant during the entire case. The plaintiff is the name given to the person suing, in this case, you, and the defendant is the name of the person being sued. Has a box underneath that allows you to identify whether it's a complaint, an amended complaint, a cross complaint, or an amended cross complaint. I'm assuming this is your first paper that you're filing in the case, so it's going to be a complaint. And then finally, is the case going to be unlimited or limited? And if it's limited, is it over or under $10,000?